doing tonight? I'll give you as much of an update as I possibly can tonight. There's not a lot to give you an update on. However, I didn't want to go much further without having one of these meetings, because even a small update with not much information at least lets you know what's going on at this point. So with that, I will say that the important things that you need to know is we did have a hearing in federal court recently. That court hearing, for those of you who were there, you heard Chief Judge Smith, who's the Chief Judge of the federal court, talk about whether or not to appoint me as a federal receiver in that case. There was a lot of discussion about it. The judge invited the parties to submit briefs on it. I will tell you that everybody, including myself, advised the court that we were not adverse to the idea of me being appointed as a federal judge. Although, I'm sorry, well, I wish I were a federal judge. And notice who corrects me right out of the gate. A federal receiver, which is not the same thing by any stretch as a federal judge. To appoint me as a federal receiver, my belief that that would not be an inappropriate thing was conditioned or tempered only by my argument to the court, or statements to the court, probably the better way to say it, that I think that the jurisdiction properly lies where it does now, which is Rhode Island Superior Court, and that while a federal receivership would not be anything that I think would hurt the case, that I believe that that would only be able to be done if Judge Stern were agreed to relinquish that jurisdiction, his control over the case. There was also some discussion as to whether or not a joint receivership should be done, meaning I would both function as a state as well as a federal court receiver. And there are many things that would happen if that were to happen. There were things that would have to be worked out. Needless to say, we had a conference with both judges and all parties early last week, and both Judge Smith and Judge Stern advised that at this time they are going to leave it as is. They do not believe that, while it does not speak to whether or not they think that it would be appropriate to have a federal receiver or a joint receiver, at this point I think that their feeling is that the way that it is configured right now works, and that we need to focus, and by the we I mean the global we, all the parties and the court, need to focus on making sure that the parties are moving in a forward direction to try to get this resolved, instead of heading down a path of years of litigation. So if a federal receivership were to help that, I think that the judges would have entertained it and would have probably put me in place as a federal receiver, but because I don't think that they see that that advances the ball in any way towards that goal, at this point in time, they've basically decided to table it. Don't read anything into that in terms of its appropriateness or anything like that. It really is purely it's working the way it is now, and the federal receivership won't advance discussions or the resolution of this any further. So, in addition to that discussion, among other things, both judges were united in their message to the parties that they are not yet ordering, and keep in mind they have the power to order it if they want to, they are not yet ordering the parties to mediate, but they are strongly suggesting that they do it voluntarily. Mediation, for those of you who do not know, is a non-binding process by which the parties get together with a party who helps to facilitate the discussion. They don't render a decision. They don't issue a judgment. They just help to show the parties where their case may be weak, where it may be strong, and where there may be room or need to flex on positions. The judges have as I said, strongly suggested that the parties do it. And I will tell you as a lawyer, when a judge tells you I'm not ordering it, but I strongly suggest it, you kind of take it the same way. Because you know that if you say no, the next response is, okay, if you're not going to do it on your own, then I'm ordering you to do it. And now you're doing it under my guidelines, not your own. So since that conference, a couple of things came out of it. One, Judge Smith ordered Prospect. As you know, Charter Care Community Board has a 15%, give or take, ownership interest in an LLC jointly with the Prospect entities, or one of the Prospect entities. That entity, CCCB, has been asking for financial records for some time. I think they first started asking for them in September, so they could properly value the value of that 15% interest. As you also know, in the settlement that we entered into with Old St. Joe's, Old Roger Williams, and CCCB, a transfer or assignment of that interest was part of that settlement. I would be getting so that I could determine the value of that interest. For a lot of reasons that aren't really important to the ultimate discussion, Prospect has not given that information, and we, along with CCCB, have consistently been telling the court and Prospect that we need the information, because the only way there's an event that's supposed to start in June that goes 90 days in terms of CCCB either seeking to liquidate that 15%, turn it into cash, or to hold on to it if they believe it's more valuable to hold on to. The only way that they can make that determination is if they have the financial information to value what that 15% is. With the settlement, that adds another layer, because now it's really an interest that they hold equitably in trust for the plan. And I need to assess independently the value of that 15% and then work with CCCB to let them know what I think the best outcome is for the plan with regard to that 15%. Prospect hasn't provided that information. CCCB's been asking for it. About 3 weeks ago, Julie? CCCB filed the lawsuit? About 3 weeks ago, CCCB filed a lawsuit against Prospect, among other things, asking them to turn over that information. Contemporaneously with that lawsuit, Prospect filed a motion with Judge Stern seeking relief to sue CCCB in Delaware, which would require me to go down to Delaware and defend, because we hold the equitable interest in that 15%. That lawsuit got filed, the motion got filed, both judges are aware of it. That was the focus of a big part of the conversation with the judges, and the judges directed Prospect to let them know, and us, within 3 days, which was last Thursday, as to whether or not they would release the financial information. In a nutshell, Prospect has been saying the reason they don't want to give the information is because, while they know they should be giving it to CCCB, they don't want CCCB to share it with me because we're suing them. Our reaction has been, we won't share it. We won't use it as part of the litigation. We'll go under what's called a protective order, where we have to keep it confidential and we can't use it for any other purpose other than the valuation. And the only way that we will is if we seek an order from the court allowing us to use it for a different purpose. Over the past couple of weeks, the parties have been negotiating the terms of not only the release of that information, but also the initial steps to start a mediation process. And I will tell you that we have provided to Prospect, at the judge's suggestion, the names of 5 different mediators, all out of state, so that nobody can say that there's any influence within the state, that we believe would be acceptable to assist us in trying to mediate. Now keep in mind, because mediation is non-binding, excuse me, anything that came out of that mediation, in order to be binding, both parties would have to agree to it. If both parties don't agree to the results of the mediation, you walk away and you're no worse off than you were when you walked in, except maybe you have a better indication of what the case is, and each side has a better indication from at least a unbiased third-party mediator as to what the weaknesses and strengths are for your case. But essentially, that's where we are right now, is we are trying to put together terms in which Prospect will release that information to CCCB. My hope is that the release allows me to not only review it, but also to participate in the valuation process, because ultimately it's important to me what CCCB determines the value of that is, and move towards a mediation. I could tell you that Thursday, is this Thursday, Julie, Judge Stern has scheduled a conference. Judge Stern circulated an email this morning asking all the parties to participate in a conference call this coming Thursday, because he wants to make sure things aren't getting stuck in the mud and that are moving along. So he wants to know the status from all parties of the release of that information by Prospect, and any movement that the parties have made towards coming to an agreement on how mediation will go forward. I will also tell you at that conference that the discussion about mediation was not limited to just us and Prospect, that the court was actually speaking in terms of any party, and even more beneficially, a global mediation, where it's Prospect, the diocese, Angel, and the receiver, who are the remaining parties in the case, all sit down and try to mediate everything in total, as opposed to piecemeal. I'm not sure if that's going to happen, but at least that has been the sentiment that has been expressed by both judges to the parties, on a very strong suggestion that that happen. And we are working towards it. And I can say that Prospect has been responsive, although we have not yet come to agreement on the terms of anything. And maybe Thursday, part of the reason why I believe Judge Stern asked for the telephone call, and I'm just surmising, I don't know this for certain, is because if there are some sticking issues to getting to the middle on a way to do it, he can help facilitate that, or order something that may help the parties. So that's where it landed as a result of that conference with both judges. Some of you have seen that there's a hearing date scheduled for April 26th. That hearing date is specific to Prospect's request to sue down in Delaware. As of right now, that may get put off. Under some versions of the discussions between the parties, there's been a request that that be allowed to go to hearing but not to act on it, depending on how the court rules on it. So basically get the hearing out of the way but not do anything, even if the court grants it. We haven't finalized what's going to happen yet. So as of right now, that hearing date is still set. But I can tell you that it may get pushed. And if it doesn't get pushed, it'll be the hearing and the hearing only, just so that can happen. There probably will not be a decision rendered at the conclusion of that hearing. The other hearing date that you may have heard about is May 8th, which is the next hearing on the next report. And I can tell you that other than being the general report that you've all seen before, barring anything happening between now and the time I file it, which will be the end of April, I think April 25th I have to have it in by, it will be just pretty much a recitation of everything we're talking about tonight, maybe one or two things more, because there will be a couple of things happening after this. So that's really where we stand right now in terms of this case. The judge has still, the federal judge has still not heard, he has received briefing on, but has not heard the motions to dismiss that were filed by all the parties. He has received briefing on, but has not heard yet the motion to approve the settlement with CCF, Charter Care Foundation, although at the hearing, the judge indicated he was going to set that down. I believe he was going to try to set it down for some time the end of April, but it may flow into the beginning of May. But he's aware that all the briefing is in, and it's really just a matter of a hearing. And that's basically where we stand right now in terms of the litigation and everything that has been going on. I will announce to everybody that some of you may have heard, may have seen, that the treasurer has submitted legislation which is geared towards preventing what happened to you from happening again. I got a phone call today about it. I know generally what the legislation is, but I have not been able to read the latest rendition of it. There are hearings tomorrow, Tuesday, at the State House, at the Rise, which is probably sometime around 5:30. They are between the Senate Finance and the House Judiciary. Those are the two committees that are hearing it. It's at, like I said, it's at 5:30. The
4:30. 4:30 in the email they sent.
All right, that may be true. What the committees are meeting after the Rise tomorrow, and the Rise is typically at about 5.
All right.
The Rise is when they end their session for the night, and then they go into committee. So 4:30 gets you there in time for a 5 o'clock hearing, but it's likely it's not going to happen until 5, more likely even 5:30. I was up there for a couple of years as counsel, and they don't move quickly when they leave the floor to go to committee. So House Judiciary meets in room 101. Senate Finance meets in room 211. If anybody here is interested in going, it's open to the public. It's open to public comment. Unfortunately, the treasurer asked me if I would go. There are 2 reasons why I can't. I'll give you the practical and then the legal. The practical is I have another commitment that I already have that I can't change. Legal is that I spoke with the judge, and I agree that it's preferred that I not get into a political process while I'm sitting in the role that I am in. However, I will say this, and I'm not shy about it, is anything that anybody in the state can do to prevent this from happening again is a welcome change to any body of law, because it shouldn't happen to anybody, and the fact that it's happened to you is a travesty in and of itself, and it shouldn't happen again. So I support any measure that prevents that from happening again. If you'd like more information on that, I can give you the bill numbers, so you can look them up online if you want, so you can see exactly what the treasurer has proposed. But again, it's tomorrow between 4:30 and 5:30, we'll say, at the State House, in front of the Senate Committee on Finance and the House Judiciary Committee. And unless I forgot something, Julie, can you think of anything that I may have forgotten to discuss? I'll open the floor for questions of any kind of nature, and as usual, I will be as honest with you as I can, and if I can't answer a question, I'll tell you I can't and the reason why. Any questions?
Mediation, would the mediator say, besides looking at the strengths of the case, could he say that he or she say that X amount of money should flow into the voter pension fund? Or we just...
A mediator generally doesn't do, excuse me, any type of fact-finding or determination like that. They basically try to get the parties to someplace in the middle. And in this case, I guess, although these aren't the exact positions of the parties, is we're walking into the mediation starting with what I believe is the number, which is about $125 million. Put aside the CCB, St. Joe's Roger Williams, and the CCF settlement. Let's assume for the moment those, because they haven't been approved yet, so that money isn't here yet. But it's $125 million to make this plan whole and protected. And let's assume for the moment, and this is not their position, so please don't post this on Facebook or anything, that prospect is at 0. So the mediator will sit down with us and start talking about the case and start exploring with the parties. Again, it's not a fact finder, so usually a mediator he would come into my room and talk to me about what do we want, the strengths of our case, the arguments we'd make, what would we be willing to take from a certain party as settlement, what do we value those claims at, and then he'd go back to the other side and he would talk to them. He or she would only reveal to the other party what the other party allowed them to reveal, so it's all a confidential discussion. And they try to facilitate that discussion. They don't enter any type of judgment or decision. They're not a fact finder or anything like that. They know about the case because they get papers and pleadings and they understand the positions of the parties walking in. But they don't act like a judge or an arbitrator. In an arbitration, you actually get a judgment at the end of it, similar to a court. But a mediator, that's not what happens. A mediator is really facilitating a negotiation.
Can I ask why in one of those court cases it would be in Delaware?
Okay. I'm going to explain this as comprehensively but as simply as I possibly can. The simplest answer is that under the LLC agreement that CCB entered into with the prospect entity, with certain issues that come up under dispute in that agreement, they have contractually agreed that the venue should be Delaware. It doesn't have to be Delaware. Delaware, one, they could agree now that it doesn't have to be Delaware. And I believe that it is one of two. It could be up here. But Prospect has taken the position that if they sue on that issue, they would want to sue in Delaware. At least that's the indications thus far and in their motions. They could change their mind. But that's basically why the parties, when they entered into that agreement, indicated that for some issues, Delaware would be the jurisdiction where they would fight about it. 1 second, yes.
Any more on the parties that you're meeting with to settle? There were some of the parties that were trying to meet with you to settle.
Well, so we have settled with CCB, Old St. Joe's, Roger Williams, and CCF. We're waiting for the federal court. Federal court actually approved the preliminary approval for the CCB, St. Joe's, Roger Williams one. CCF will be coming up probably the end of April, beginning of May. In addition to that, that leaves the prospect entities, the diocesan entities, and then Angel. We've been talking with a couple of them, not all of them, but the conference that happened last week was really, I believe, the catalyst to not only get the ones that we were already talking to, but everybody to understand that we all need to sit down at the table and we need to discuss it. Mediation may not work. Arbitration might not actually work. But I believe that I owe it to everybody sitting here and everybody who could be but isn't sitting here to at least try, because mediation will short-circuit the time frame to come to a resolution. So a lawsuit, to take the entire length of that lawsuit, depositions of discovery, motions, you've already seen how long it takes to even get the motions to dismiss heard. So litigation takes a long time. Mediation does not. In my mind, aside from the valuation of that 15% interest, I think that a mediation with some starts and stops would take the equivalent of maybe a month's worth of time. Equivalent of a month's worth of time spread over maybe several months, but not several years. The valuation would take a little bit longer, maybe 90 days, 120 days, something like that. But I believe that mediation, if successful, could have us here at the same time next year being in a very much different discussion, because we might be just talking about what we're going to do with what we've recovered as a result of those settlements, as opposed to talking about where we are in the litigation, which will only be maybe 25% in or a third in or something like that. So that conference with the judge was to not only encourage the discussions that have already happened, but to encourage discussions with those parties who haven't come to the table yet. So that's what we're doing right now. Nothing other than those settlements you've seen has been reached, but I do continue to have those discussions.
I just wanted to ask, how is the fund doing?
Well, relatively speaking, the fund is doing well, and I say that because the market has been much more volatile over the past, say, 8 months than it had been for a number of years prior to that. We had some substantial losses walking into 2019, the market did, but January, February, and March, those actually recovered and then some. So we are, notwithstanding the fact that we don't have any money to put into the plan is, while it is eroding because benefits go out every month and no money is coming in, the investment income that we're earning on the investments is keeping us better than a break even. So if we're, just as an example, if we pay out $12 million a year in benefits, we're bringing in slightly more than that right now in investment income. So we're still losing money at the end of the day. We're just losing it more slowly as a result of that investment income.
Now, has any of the money that we've recovered been able to be put into the plan yet, or no?
No, that won't happen until, under the class action process, the federal court has to give preliminary approval to a settlement, and then it has to set a hearing down for final approval. So we've received preliminary approval. Actually, the judge hasn't issued the decision yet on that. Judge, I'm jumping the gun a little bit and maybe being optimistic. Based on the conference the other day, I think we will be seeing preliminary approval of the CCCB settlement soon. And then we'll be going in for preliminary approval of the CCF settlement. Once that happens, the court, number of parties have to be notified. A number of your counterparts are spread throughout the country, so because it's a class action, the attorney generals in the different states have to be notified. And then the court will be presented with a request for final approval. Once the court issues final approval, then those funds would be available to flow into the plan, but not until then. Yes.
So at this point, if they approve any funds to go into the plan, do they just go into the plan, or is there an option that, we are three different groups, majorly speaking here? Is this where people will make a play for, I want 60% of that money, I want 40% of that money, I think I should have it all? Or does it just go into the plan as a whole and that gets dealt with later?
It's the latter. It would go into the plan to fund the plan, because as of right now, while there are at least 3 defined groups, you all have the same goal at this point. And the goal is to allow everybody, regardless of whether you're 101 or 41, to receive the pension that you believed you were going to get for the rest of your life. And the only way that that's going to happen is if the entire plan gets funded. So before there's any, I'll call it jockeying for position, we need to know if there's a need to jockey for position, and if so, where do the plan assets fall, to see exactly how that's going to work itself out. Sure.
Does all of the involved parties have to agree on who the mediator will be and who pays for it?
The general way that it works is that all the parties do agree. The reason why, as to who the mediator would be, the reason why we've submitted 5 names is because it was suggested by the court. We believe it's appropriate that it be an out-of-state mediator. And so we're hopeful, although there are a lot of mediators out there, but we're hopeful that by giving 5 names, it's possible that the prospect entities and or the diocese or somebody will give their list of names, and there might be commonality on 1 or 2. That makes the decision easier. The judges did indicate that if the parties cannot come to terms on a mediator, on who that mediator is, they will identify the mediator for us. So one way or the other, either we're going to be able to come to agreement on the person, or the court will tell us who that person is going to be based on the names that are put before it. As to who pays for it, that's a very good question, because it is generally paid for, some people believe it should be paid for 50% by the plaintiff, 50% by the defendant. For obvious reasons, I am not in that school for this mediation. My position is that each of the parties should pay their proportional share. So if there are 10 parties, everybody pays 1/10 of the fee. I have not heard yet, but I would imagine that the prospect entities and the diocesan entities would not be in favor of that, because they view themselves collectively as one, but yet I've sued individual named entities. So there'd be like 3 prospect entities and 3 diocesan entities. So we do know we're sharing the expense, but there has not been a discussion as to how that split is going to be. That usually does not come until the mediator is chosen, and quite frankly, till you find out how much the mediator is charging. If the mediator charges a lot and everybody thinks this is going to be hours and hours and hours, then people fight about it a little bit more strongly than if it's, a $3,000 mediation bill. Not many people are going to fight about how to split that up. Any other questions? I will say there will be, between now and I'd say May 8th, which is the hearing on the next report, because of the judge's involvement and the judge's pushing the parties to actually try to come to mediation and get that information from Prospect over to CCCB and things like that, there will probably be more happening over the next few weeks. As a result, I will probably, we've been doing it every 6 weeks now on the meetings, roughly. I will probably schedule the next one maybe a little bit sooner, just because if there are some major events that are important for you to know about, I don't really want you to have to wait 3 or 4 weeks to hear about it from me. What you read from the court pleadings is all fine and good, and what you even hear at the hearings is all fine and good. But I'd like to think that the way that I explain it may be a little bit more down to earth, although Julie might disagree with that on a number of occasions. So again, if there are no questions, yes?
Have you heard any more progress on ERISA?
That's a very broad question you just asked. Have I heard any more progress or had any more progress with ERISA? I will answer that in this way. I continue to look at that issue, continue to prepare to deal with what I think is the best way to deal with that issue. We continue to communicate with the IRS, the Department of Labor, and the Pension Benefit Guaranty Corporation in terms of providing them with all the pleadings that are filed both in federal and state court, to the extent that they ask for information, any information they've asked for, which they haven't asked for any in a while. And so that way, at the very least, those agencies are fully informed as to what's going on. But as to a position other than what we've asserted in the lawsuits, which quite simply what we've asserted in the lawsuits are, it's been treated as a church plan for a number of years. We believe that it's been an ERISA plan for a number of those years in the recent past, as maybe as early as 2002, 2009, something like that. We could be wrong on that, in which case the church plan argument is correct. We could be right on it. So we've actually argued in the alternative, that if it's a church plan, this is what should happen. If it's not a church plan, this is what should happen. And as of right now, those are the positions we have. Is factually it was treated as a church plan. We disagree that it should have been treated as a church plan for at least some of the recent past. It should have been an ERISA plan, and that created some liability on some of these parties. But I could be wrong on that, and I'll wait for a judge to tell me. And in the meantime, I may take some actions that are necessary to either assist that position, preserve that position, whatever the case may be. But that will be after consultation with experts and review and making sure that whatever move I make with regard to this plan, whether it be an investment or addressing the issue like ERISA, that it's intended and will have the biggest effect on protecting and preserving the plan. So unfortunately, that's all I can give, is that we've been communicating, but there's been no determination by anybody yet, a court, an agency, and certainly I can't make the determination. I need one of them to do it as to whether or not the position is correct that it hasn't been, or the position is correct that it has been a church plan.
So were you saying, Steve, that it doesn't necessarily have to be PBGC, that it could be the court that makes that determination?
I can tell you this somewhat conclusively, because PBGC has said this to me, is the PBGC does not determine whether or not this is or is not a church plan. There has to be a determination by the IRS, which has to be requested in order for it to be considered or to be ruled on whether or not it is or is not a church plan. Alternatively, we can ask, as we have, a judge to make that determination, and not only make that determination as of today, but make that determination retrospectively to look back and say, okay, as of, just as an example, 2009, it ceased functioning as a church plan and was an ERISA plan, and by not doing A, B, and C, it was a failure to comply with ERISA, and this is what flowed from that. So you can either get that determination from the IRS, I believe even the Department of Labor can do that as well, or maybe they do it in conjunction, or we can seek a determination from the court. We are at this point moving in that latter direction where we're seeking the determination from the court.
So that's why there was so much discussion at the federal court hearings about, is this ERISA, is it not ERISA?
That's correct.
Okay, because I didn't understand why it was being talked about there, thinking that PBGC had to make the decision.
And again, I'm going to simplify it a little bit, but what I believe it was Prospect's attorney was arguing, they took the primary oar on that argument, was that, okay, the receiver has set forth that this has been an ERISA plan since 2009. Well, if it is, they've questioned the jurisdiction of Judge Stern because they said that a state court can't have jurisdiction over an ERISA plan. They've questioned what I've done at the direction or with the approval of Judge Stern, because if it's an ERISA plan and he doesn't have jurisdiction, then him telling me yes or no to do something is of no force and effect. And if it was an ERISA plan, then ever since I've been in place, I was supposed to put aside what everybody else was supposed to do. I was supposed to do A, B, C, D, and E. I didn't, so now I'm in violation of ERISA, and the court needs to consider that. So their whole argument was, if you believe that argument that this has been an ERISA plan prior to, and I believe they said that there's no dispute that it was not a church plan as of the date that I was appointed. That's different from saying it was an ERISA plan as of the date I was appointed. Well, that's a question too. So what is the effect of the receivership on it? So these are all very kind of complicated legal questions that quite frankly haven't been answered by any court in any state in the country. So these issues are novel, and you heard Judge Smith say to us at one point, it looks like you're having your cake and you're trying to eat it too, because we're arguing that it was an ERISA plan, but we're saying, but we could be wrong, so if we're wrong, it was a church plan. He's like, well, you got to kind of pick. And we were saying we can't, because our argument and the facts, those need to be squared against each other, and they're not right now. It's been treated like a church plan. There's no question about that it was treated like a church plan. But the question is legally, should it have been? So if they were legally correct in treating it like a church plan, okay, one of our arguments fails. If they weren't, then another argument fails. But we have one to lie back on because the facts are what we're actually working on, along with the legal analysis. You can't square the two right now because it's been so, this is a legal term, screwed up for so many years.
It's a legal term?
That's my legal term, yeah. Any other questions? Okay, with that, as always, I want to thank everybody for coming out. Like I said, the 26th may or may not get moved, but even if it doesn't get moved, I think that that will be a hearing without much consequence. You may hear some things that are interesting, but I don't believe that the court will rule on it right then and there, especially in light of the positions of the parties about mediation and the court's preference on that. And then my report on the 8th will go forward. But barring anything tremendous happening, it will be more of a administrative report to the court as to what's going on, which will be similar to what you heard tonight, plus whatever happens in between now and the time I file it. Drive safely. Enjoy that the weather has finally started to break a little bit, and I will see you probably in about 4 weeks, if not sooner. Thank you.